Hello, class. Today we're going to look at legal aspects in healthcare. Be patient with me as this is a long PowerPoint presentation, but we'll try to get through it as soon as possible. When we think of legal aspects of healthcare, we think of common law. The common law is a law that's established from a court decision, which may explain or interpret the other source of law. An example would be a physician has an obligation to use reasonable care in treating a patient, not commit malpractice. This is a legal obligation that the doctors, healthcare workers, and anyone in the medical field have decided that they would follow no matter what. Precedent. A ruling in a previous case may be applied to subsequent cases. So what does all of this mean? Well, let's look at a case example. In 1616, case of Weaver versus Ward Weaver sued Ward after Ward's musket accidentally fired during a military exercise, wounding Weaver. Weaver won, and Ward had to pay damages for Weaver's injury. The court concluded that Weaver did not have to show that Ward intended to injure him. Even though the injury was accidental, Ward was still liable. There's also another example, if you would like to read that, where it's the case of Lambert versus Bessie, decided in 1681. When we talk about legal aspects and we talk about these case examples, basically it's just holding you accountable for your actions, turning your wrong into a right, regardless of what you may believe is the truth. You still have to hold yourself accountable and liable for the decisions that you make. Classifications of law. Civil, private law concerns relationships between individuals or between individuals and the government. It involves all the law that is not a criminal law, although the same conduct may violate criminal and civil law. An example would be murder. Tort law. This is one you're probably going to want to remember. Tort is a wrongful act that is committed against another person or property that results in harm. To sue for tort, the patient must have suffered a mental or physical injury that was caused by the physician or the physician's employee. So what would that look like as far as an example? Let's say a patient goes in and they're scheduled for a right knee replacement. After the procedure is done, the patient wakes up and they realize that the left knee was replaced instead of the right knee. Therefore, this patient would fall under the tort law of a wrongful act committed against themselves. Torts can be intentional or unintentional. In this case, we would want to assume that it was an unintentional and it was just a mistake. Unfortunately, as we had said previously, that all mistakes, we need to be held accountable for those actions. Under the tort law, if a wrongful act has been committed against another person and there is no harm done, then there is no tort. With the example that I had explained, there would be tort due to there was another person harmed. However, in medical practice, every wrongful act or error must be reported since patients may experience harm, sometimes later than when the tort occurs. An incident or event reporting. Working in the healthcare system for many years, anytime that a patient would perish or pass away, we would have to fill out an event report. If a patient was giving a medication that they had an allergic reaction to, you would have to fill out an incident report. They are just two examples. I have an extensive list that you can see: adverse outcomes, procedural breakdowns, and catastrophic events. They would be an unexpected death or disability, inpatient falls or mishaps, institutionally acquired burns, institutionally acquired pressure sores from a patient lying and not being repositioned, on an hourly basis. Errors or unexpected complications related to the administration of drugs or transfusion given the wrong dose. Discharges against medical advice, also known as AMA. Patients are notorious for signing out AMA if they do not have the money or they do not want to receive the treatment. Significant delays in diagnosis or diagnostic testing. Breach of confidentiality, also known as HIPAA. Performance of a procedure on the wrong body part, as we explained with the right knee replacement versus the left knee replacement. Performance of a procedure on the wrong patient. We have had patients come in with the exact name and date of birth, and their charts have gotten mixed up before. I have seen it happen. It is very rare, but it does happen. Infant abduction or discharge to the wrong family. There are rules and hospital policies in place now where we don't see this too much anymore, but it does still happen. Rape of a hospitalized patient and suicide of a hospitalized patient. Now we're going to get into intentional torts. What would fall under an intentional or you want to cause harm to someone? First would be assault, the threat of bodily harm to another. There does not have to be actual touching, aka battery, for an assault to take place. An example of this would be threatening to harm a patient or to perform a procedure without the informed consent of the patient. Battery, actual bodily harm to another person without permission. This is also referred to as an unlawful touching or touching without consent. An example of this would be performing a surgery or a procedure without the informed consent of a patient. A lot of times in nursing homes, you will see the intentional torts of the elderly being mistreated or treated without their permission. False imprisonment, a violation of personal liberty of another person through unlawful restraint. An example of this is refusing to allow a patient to leave the office or hospital when they're requesting to do so. This can also fall under unlawful restraint. Defamation of character, damage caused to another person's reputation through spoken or written words. Rumor is the best way to describe defamation of character, starting a false rumor or a rumor based on your opinions only. An example of this would be making a negative statement about another physician's ability. Fraud, deceitful practice. An example of this might be to promise a miracle cure. You've seen in the news multiple cases where physician's assistant, they get charged with fraud because they are practicing deceitfulness with their patients and making promises that they can't live up to or they simply just can't keep. Invasion of privacy, the unauthorized publicity of information about a patient. An example of this would be allowing personal information, such as test result for an HIV and any other patient information to be released without prior consent of the patient. That is where the HIPAA law comes in. Again, you cannot discuss patient history unless you're discussing it with the physician and you have the patient's consent to do so. Unintentional torts, such as negligence, occur when the patient is injured as a result of a healthcare professional not exercising the ordinary standard of care, meaning that they neglect their patient, they don't check on their patient, and they're not following the protocols that they're supposed to. Definition standard of care. The professional must exercise the type of care that is reasonable, meaning the person would use in a similar situation. Use your best judgment. I think this is a great case example of unintentional tort. If you're a phlebotomist and you're drawing blood from a patient and you allow the patient to stand up, that is not standard practice. Standard practice would be to have the patient sit down, put their arm out, make themselves comfortable, and if they're feeling any kind of discomfort or lightheadedness, they should let you know as soon as possible so that the patient is not harmed during the drawing of blood. Informed consent, the process in which a patient is apprised of the procedure's risks and benefits and freely consents to undergo the proposed treatment. Requiring the patient to sign a form is not informed consent. An informed consent must be signed voluntarily, meaning the patient isn't under any kind of enhancers or drug or alcohol influencers. Describe the procedure for which the consent was given. Answer all of the questions for the patient. Show that the consenting person understood the nature of the procedure, the risks involved, and the probable consequences. Patient cannot be sedated when they're doing informed consent. Now you will see if you go into the cath lab, there are patients that come in urgently or emergently, and the patients may have had some morphine or some nitroglycerin to relieve their pain before having a cath procedure done. In an emergency event, it is not uncommon for the informed consent to be signed after the patient is sedated. This does not fall under the legal aspects of healthcare. You guys can read over this next slide. It's informed consent from the American Medical Association and their requirements, legal requirements, I should state, to get informed consent. Competent adults. An adult is competent if a court has not declared the person incompetent. The person generally is capable of understanding the consequences of alternatives, weighing the alternatives by the degree of which they promote his or her desires, and choosing and acting accordingly. We would be considered a competent adult because we are not under the influence of anything and we are able to make our own decisions. You are allowed refusal of consent. Competent adults have the right and capacity to not only consent to medical treatment, but also to refuse the medical treatment. A treatment refusal must be honored regardless of the basis on which it is grounded. As a reminder, some patients refuse treatment for spiritual or cultural reasons. The best example to explain this is there are cultures who it is against their religion and against their beliefs to be able to accept any kind of blood products. It's in their chart and it must be honored. If the patient knows that there is a chance that they could perish, if they do not receive blood products, it is their choice to refuse consent as they feel that they are honoring their religion opposed to accepting the blood products and going against their religion and being shunned by their community. Incompetent adults, if a patient is not competent to give informed consent or informed refusal, the patient's guardian, or if no guardian exists, the representative of the incompetent adult patient. This person makes decisions on the patient's behalf. This would be patients that come in that they have given consent or a power of attorney to a sibling or a parent or a guardian to make the decisions for them as they feel they can no longer make these decisions on their own.